Unit 5, Chapter 15. Lecture: Common Law and the Jury System.
The legal system of a country, that is, its system of justice, reflects the history and culture of the country just as much as other topics we've discussed so far. When we start to discuss law, courts, trials, and concepts of innocence and guilt, there are some broad philosophical questions that come up, questions that might be interesting to think about before talking more about the legal system in the United States. Because people from different cultures might answer these questions differently, let's take a few minutes and see how you would answer these for your country. Now, the first question: is it preferable for a dozen guilty people to go free rather than to punish one innocent person unjustly? Or is it sometimes necessary to punish innocent people so that no guilty person escapes justice? Here's another question for you. Is a person guilty until he is proven innocent? Or does it seem more logical to you that he is innocent until he is proven guilty? I suspect that the average person in the legal profession in the United States would say that it is better to let a dozen guilty people go free rather than to punish one innocent person unjustly. In addition, the guiding principle for the U.S. legal system is that an accused person is innocent until proven guilty. Now that you've had a chance to think about these two philosophical questions, let's look at the U.S. legal system in terms of what makes it different from legal systems in many other countries. First, we'll look at U.S. common law and how it differs from civil law as practiced in many countries of the world. Then, we'll look more closely at the jury system, a system that many foreigners find quite curious. Then, if there's time, I'd like to make a few concluding remarks about plea bargaining, the way that most cases, in fact, are settled out of court. I think then that you'll be able to get a feeling for how the United States' approach to law is different from that in your country. To begin with, the U.S. system of justice is not unique. We have to remember that it is a system brought over by the first settlers from England. At that time, there were two basic legal systems in Europe: common law, as practiced in Great Britain, and civil law, as practiced in other European countries. To simplify greatly, civil law depends on a written code of laws. In deciding a case under civil law, the judge consults this code, a complex set of written laws, to decide whether the defendant is innocent or guilty, and, if guilty, what sentence the defendants will be given. On the other hand, common law, generally practiced in English-speaking countries, including the United States, has developed case by case. Besides considering written law to determine the defendant's guilt, under common law, the judge also considers the precedent set by other court decisions. In deciding a case under common law, then, the judge looks at what other judges have decided in similar cases in the past. So the judge is guided not only by a legal code, but also by previous court decisions. And very often, it is not the judge who brings a verdict under the common law, but the jury. The U.S. Constitution guarantees the right to trial by jury. A jury is a group of 6 to 12 ordinary citizens. The jury hears testimony in either civil or criminal trials and reaches a verdict. A civil trial is one that deals with disputes between private parties, often involving contracts or property rights. Criminal trials are ones where the government, representing the public, prosecutes those accused of a crime. In a civil trial, the jury decides which side is right and how much money should be paid in damages. In a criminal trial, the jury decides guilt or innocence. There are two other big differences between criminal and civil trials. First, the defendant in a criminal case does not have to testify. It is the government's job to show guilt, not the defendant's job to prove innocence. In a civil trial, the defendant must testify. Second, for a jury to convict a person in a criminal case, they must believe the person guilty beyond a reasonable doubt. The government must present a high degree of proof. The jury in a civil trial decides which side has presented more evidence to support its case. This is a lower degree of proof than reasonable doubt. The reason that the degree of proof is much higher in a criminal trial is that a person's liberty, and even life can be taken away if he or she is convicted, that is, found guilty of a crime. The judge at a trial and the jury have very different responsibilities. The judge's main responsibility is to see that the trial is conducted according to the law. Part of this responsibility is excluding irrelevant remarks and questions by lawyers and witnesses, and deciding what kind of evidence is admissible. The jury, on the other hand, decide whether they believe the testimony they hear and whether the evidence presented to them is valid. Some of you may remember the trial of the American former football star O.J. Simpson for the murder of his ex-wife and a friend of hers named Ron Goldman. Mr. Simpson was found innocent in 1995 by the jury at his criminal trial. However, a year later, he was back in court. The families of his ex-wife and Ron Goldman brought a civil suit against O.J. Simpson. At the end of this civil trial, the jury awarded millions of dollars in compensatory and punitive damages to these families. Most people favor the jury system. However, it also comes under criticism. Some people criticize the way juries are selected. Some believe that juries make decisions based on emotion rather than facts, or that jurors may not have the education or background to understand some complex legal issues. One serious problem is that if the required number of jurors cannot agree on a decision, it is called a hung jury, and the law requires a new trial with a new jury. I don't want to leave you with the impression that every legal case is tried in court with a jury in the United States. In fact, only about 20% of legal cases actually reach the courts. What happens is that in civil cases, most often the two sides settle their dispute out of court with the aid of their lawyers. And in criminal cases, very often a person accused of a particular crime will plea bargain. What actually happens in plea bargaining is that the accused pleads guilty to a lesser crime. Why is this allowed to happen? This is allowed to happen because there is a large number of civil and criminal cases. If all these cases went to trial, the courts would be very crowded. If an accused person agrees to plead guilty, there will, of course, be no trial in court. This saves the state time and money. Also, the accused person who plea bargains often is allowed to do so only if he or she also cooperates with the prosecutor in bringing other criminals to justice. From the accused person's point of view, the sentence might be less severe than if he or she went to trial and were found guilty. Though what goes on in court is often routine and not exciting to observe, jury trials often have very dramatic moments. In fact, courtroom drama has been the subject of many films made over the years. If you have the opportunity, I would encourage you to watch one or two to get a better idea of how a jury trial works.